Okay, hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is a conference call for our community that we do every 2 weeks. The answers here are subject to the disclaimers that you hear when you log in. There is no attorney-client relationship. Information is the best we can. There's no guarantee of it. This is not a substitute for an in-depth consultation. With that, let's just make sure you can hear me okay. 1 second.
The conference is now in conversation mode.
Can you all hear me okay, folks? Am I audible? Hello? Hello?
Yes, you are.
Okay, excellent. Thank you. Back to conversation.
The conference is now in presentation mode.
So, folks, as we always do, I'll first go over the questions I think are frequently asked, and I'll invite your further questions on the topic being discussed. And that pattern will continue through until we've answered all our questions. And if time permits, then we'll answer more questions. So the first frequently asked question was, change of jobs with an approved I-140 from employer A and reapplying PERM through B. As we have discussed many times before, once you have an I-140 approved and it stays approved for 180 days, both your I-140 priority date as well as your right to extend H-1B beyond 6 years with any employer becomes secure. This is after 180 days. If the I-140 is revoked after or before 180 days, your right to extend H-1B goes away, but your priority date remains yours. So the priority date becomes your property the moment the I-140 is approved. Even if the I-140 is revoked the following day, your priority date is safe. Your right to extend H-1B becomes safe after 180 days. So this we have made clear before. Now the question here is a little different. I've got my I-140 approval. I went from employer A to employer B. I don't know how long I'm going to go with B. I may move to C. Is it worth applying for a PERM at this position at employer B? And the answer is obviously it depends upon what your intentions are. If you're going to be there just for a few months, I don't see any point in applying for PERM because there's no requirement in the law that somehow you have to maintain continuity of PERMs through different employers. So if you go from employer A to B to C to D to E, if you want to just file PERM through E, it is not necessary that you should have applied for PERM through B, C, and D as well. Okay, so if you want to skip employer B, with whom you do not know how long you want to stay, you could very well go to C where you want to stay for an indefinite period of time and start the PERM there. No law that stops you from doing that. And I don't see any particular benefit in it either. So if you are going to just keep moving employers, I would say hold off until you know where you're going to be working. Okay? *5 if you have a follow-up question on this. Press *5 if you have a follow-up question. All right, let's go on to the next frequently asked question. This is about an L1A. Who wants to know the impact of reportees outside the USA or in third countries when you are trying to go for an L1A and EB1C? Okay, so here is what you need to remember. There are two aspects to an L1 EB1C petition, both of them. What are the two aspects? Do you supervise people and professionals, and where are they located? There are two aspects, right? So let's say, again, further, this has to be measured both in the context of the American job and the foreign job. So let's say that your company is headquartered in India, and the company has a sister office or a branch or a subsidiary in USA. So let's say you move to Canada, but you are supervising people in India and Europe. does that count towards your L1A requirement of being an executive or managerial employee outside the United States for a foreign company or for the headquarter? The answer is yes, because you are reporting to India, that's the headquarter, and you are working outside the United States. The fact that your reportees are in third countries shouldn't matter. So in my view, that is enough for you to meet the requirement that your job outside the United States was executive or managerial. Now comes the second aspect. Let's say you move to USA now. Now where are your reportees? Are they inside USA, outside USA? If they are inside USA, great. If they are inside and outside USA, are they working for your company in USA or are they working for some other companies which are sisters? So overall, what we look for is a coherent scheme where the benefit of the work is flowing to the US company if we are comparing or if we are determining your executive or managerial capacity in the US company. So when you were in Canada, you were supervising employees for the Indian company. When you are in USA, you must be supervising employees for the US company. Are they in India, third country? Doesn't really matter. But there has to be a cohesive scheme. There must be, all these benefits must be flowing to the American company. We've had this situation come up before. And actually pretty much this fact pattern that I gave you, that's exactly what happened there. And we were able to show that the person we were moving, who was the controller, the financial vice president, was actually managing the finances of 3 different companies. And they were fairly good-sized companies. And first, the case was denied, but then they approved it because we were going to go to court over it. So the point is that when you have reportees outside the USA, it could matter for both L1 and EB1C, but it's quite manageable as long as the benefit is flowing to the company that you're working for. You're managing a big team in the USA. You have some reportees in Mexico. That's fine. Especially if they are employees of the US company, that's even easier. You're moving to Canada, you don't have any team in Canada. You'll be managing mostly the same US and Mexico team from Canada. I think that's, well, the question is, to whom are you reporting? I actually had another situation like this recently. So this is something you should discuss very carefully with your lawyers, because your situation is not that you are managing a team in India or Europe. You are actually managing the same employees from Canada. Okay. Are these employees of the American company? Is that even permitted? And the answer is probably yes. We had a weird situation in which the gentleman was, and this is very much like your situation, the gentleman was managing a team in America from Canada. We have this case pending actually, it's not yet approved. But I looked at the law and I thought that would be okay. That was my feeling. Okay. Why? Because in Canada, they didn't have a company, but they qualified the American company to do business in Canada. So it became like a branch office, not a separate entity. And I thought that would work. We got the L1 approval. Now the question is, am I going to get an EB1C approval? I think I will. Well, actually, I take that back. I didn't get an L1B approval. That gentleman arrived in USA based upon an H1B. He already had an H1B. So we just had to do an amendment. But the EB1C is pending, and that could be pending several months. I don't know how it's going to go, but I think it should work. Okay. Why? Because the employees are actually the employees of the American company, which is subject to a branch outside USA. So that can work for EB1C. Okay. But double check. Have your lawyers look at it very carefully. This is tricky. My spouse is working on H1B. If I move to Canada, can she join me for 2-3 months work from Canada? Sure, absolutely. She can maintain her H1B as long as she gets paid the American salary. Personally, I think even that's debatable. But if she's getting paid the American salary and working from Canada, no problem at all. Okay. *5, if you have a follow-up question on this, *5. press *5. Okay. This one looks like from Texas. Area code 214. Are you in Texas?
Yes, sir, Rajiv. Thanks for your answer. So my situation is like, I live in Canada, and both my manager and my reportee will be in the US.
Yeah, that's the situation I just described to you. That's the EB1C I have pending right now. And I think it'll work.
Okay.
Okay. The only thing I would recommend is talk to your lawyers and see if they can qualify your American company to do business in USA. Oh, sorry, in Canada. Because that really is very important. Just have them look into that.
No, yes. So my company has more than 50,000 strength, and there are thousands of people in Canada as well.
Oh, then you're
But
fine.
my team is not there.
I think you should be fine, but please have it double checked. My case was straightforward. This case is a little bit more complicated. You'll be reporting to the Canadian company. Would you get paid by the Canadian company?
Yes.
I think it could work, but have it double checked. I don't think the law requires me to necessarily manage a team in Canada. I think it could work even if you manage a team in USA from Canada. I'm trying to remember, we had a case in UK, very similar again. The guy was reporting to a global CEO in USA, but his company that he started in UK was in UK. Government never questioned me, well, how is the UK company he's employed when he's reporting to a global CEO in USA? But that's the way it was. It worked out fine. And that guy actually has his green card now. But he was managing a team in UK as well as USA, if I remember correctly. Okay.
So, I am planning to recruit few local people in Canada as well for my team.
I think that's perfect.
There will be only one layer of reporting under me in Canada. Will that work?
I think so. Especially if the people you recruit are professionals, for example, engineers or people who require specific degrees. Okay. If you are more into sales and all, it may not work.
Okay.
All right.
And since I'm going for 1 year, so I need to wait exactly 1 year for apply for petition, or I can file the petition 3 months before.
No.
I will coming back after 1 year.
You cannot even file until the complete 366 days. If you come and visit USA, that extra time might have to be added on to your 366 days. Okay.
So I can't even file the petition before 365
No,
days.
you cannot.
Okay. And last question. So if my spouse comes in Canada,
I already answered.
To work for 1 or 2 months.
I already answered
that. File the taxes in Canada?
That I don't know. Tax laws are not my field. Tax laws are, you need to talk with the CPAs. No idea. But immigration law,
Thank
yes,
you so much, Rajiv.
No problem. Good luck, sir.
Thank you so much.
Okay, we have another question, but make sure it's not a new question. Area code 315. What is your question?
Sorry, mine is related to travel, but I'll wait.
You're going to have to wait. Let me finish my questions first, please. Okay, no new questions, guys. Let's go back to the next frequently asked questions. Are L1B visa holders eligible to work remotely? And the answer is yes. Unlike H1B, L1 is not tied to a particular location. As long as you don't change the terms of your engagement. For example, let's say that you've gotten approval to work at a client site and provide some deliverables to the clients, and that situation has been presented to the government. They've approved the L1B. As long as you continue in that relationship, or you are reporting back to your company and providing deliverables to the company, where you are sitting doesn't matter. Thus, L1B holders are not geographically tied down, but they are tied down to their terms of engagement. So if you changed clients, I would probably want to do an amendment, because L1Bs are, when you work at third-party sites, are subject to certain limitations. Most important one is that you continue to be an employee of the company that sponsored you. Okay? But you are not tied to to a location. You can work from anywhere. Press star 5 if you have a follow-up question. Press star 5. Okay, this is area code 315. Area code 315, where are you calling from? Hello?
Yeah, can you hear me?
I can hear you. Go ahead, sir.
Hello?
Where are you calling from?
Yeah, I'm calling from Virginia.
Okay.
So I have a question regarding the same. So I will be traveling to India on 24th November on F1 OPT visa, and I wanted to know if there will be any problem while returning back
Okay.
in a month.
Well, first of all, it has nothing to do with the question that was being asked. Okay. So please don't do that, guys. Don't break discipline. It makes my life a lot more difficult. So, secondly,
Sorry.
whether you'll have a problem or not, there are too many variables for me to comment. So what I want you to do is go to our blog, go to immigration.com and read my blog. In the last 15 or 20 entries, I have one that deals with travel. Okay. So as long as you have a job
Okay.
and you are coming back to that job, your visit is short, it doesn't exceed the time permitted. There are many variables. I'm just giving you the quick rundown. And you talk to your DSO before you travel, get your I-20 endorsed for travel. You should be okay traveling. I don't have any problem with it. Okay.
Okay, perfect.
Good luck.
Thank you so much, Rajiv.
You're welcome. Okay. Next question. Let's see. I thought there was another frequent. Yeah, there is. So this is approved EB2, EB3, interfiling to EB2 with employer A and employer B. Okay. So I'm not sure what this question is. I don't remember. I have adjustment of status with I-140 downgrade in EB3, which is pending. I've got my EAD AP. I have H-1B with the same employer since 2024. I want to use my AP for a trip abroad and come back on H-1B. Come back and keep working on H-1B. Currently, the EB3 final action dates have retrogressed. I have both EB2 and EB3 I-140 approvals. Okay, got it. In case of my EB2 date becoming current, will I be able to interfile and ask USCIS to consider the EP2 case, also provide feedback on this scenario with the same employer as well as a different employer? All of this is tied to one real question. When I return from outside the United States using my advanced parole and continue my old job on H-1B, what is my status? So the first answer I have for that, and I'm going to have to look into this. I will update this frequently asked question. I'll look into it. There is no doubt that for purposes of amendment, extension, transfer, etc., you are considered to be on H-1B by the government. But can you also be considered to be in full status so that you can change jobs, do all kinds of interfilings, etc., which might require status rather than just an H-1 designation? Okay, so it appears that the government might have created unwittingly or wittingly another category of people apart from status, out of status, unlawfully present, authorized period of stay. There are all these technical jargon, but then there are those people who have traveled on advanced parole. They've come back on to resume the same job on H-1B on which they left. Are they still considered to be on H-1B? Yes. For the purposes of amendment, extensions, transfers, yes. But are they also on H-1B for the purposes of I-485, for example? I'll have to double check this. I'm not sure about it. So the interfiling will also depend upon that. I think you can. I would be absolutely shocked if there is any law that says you can't interfile, you can't change from EB3 to EB2 with both cases approved. But I will double check this, and if I find the definitive answer, I will update this both on our blogs as well as on the frequently asked questions in the Economic Times. Okay. On my author page in the Economic Times, you will see some of these frequently asked questions reported. Okay. So I'll double check this for you. In my view, it should be possible when you enter on advanced parole to still interfile as well as change employers using supplement J, etc. Okay. And it should be possible to do it with any employer after 180 days. That's the way I see it. The key question here is, what is the status of people who re-enter the United States using their advanced parole instead of H-1B visa? By the way, this can also be corrected if there is a problem. Before you undertake any changes, step outside USA, go get your H-1B visa stamp, come back, and you can go to Canada or Mexico and come back using H-1B. There's no doubt that you're back on H-1B status. Okay, so let's leave that aside for a moment. I will double check. I will update. All right. Star 5, if you have a follow-up question or comment on this. Star 5. Okay. Area code 201. I believe that's New Jersey. New Jersey, go ahead, please.
Thank you, sir. So, in the same line, the question is that if we change the employer after coming from AP and I have a EB2, EB3 with the older employer. Now I change the employer. Now my EB2 became current. I'm with new employer on more 485G.
Okay, your question, hang on, sir. Your question is the same as the one I've just addressed, which is, if I come back using advanced parole, then I change employers with an H-1B transfer, can I interfile? And the answer is, I think you can, but I will double check. All right?
Sure.
Good luck.
And then one last question is that 140, 140 is considered, we have to take considered 6 months after the approval, or it can be pending, so since more than a year, and now it has been recently approved.
Until
6 months yet.
Okay, until I-140 is approved, you have no AC-21 benefit. Okay, until I-140 is approved. But once it is approved, we look at how long has the I-485 been pending. So let me give you an example. Let's say I file your I-140 and 485 today. Okay, I-140 is pending for 5 months. Okay, let's 150 days. I-140 is pending 150 days. On the 150th day, it gets approved. You become eligible for AC-21 in 30 days, not in 180 days from the 150th day. Why? Because once the I-140 is approved, we just look at how long was the 485 pending. The moment it becomes pending for 180 days, you are eligible. Let's take another example. You filed I-140, 485 together. Your I-140 was pending 1 year. I-140 gets approved after 1 year. You become immediately eligible for AC-21 because your 485 has been pending 1 year, more than 180 days. Got it?
Thank you very much.
You're welcome.
Yeah, that's great. Thank you, sir.
You're welcome. You're welcome. Area code 903, where are you calling from?
Sir, California.
Go ahead, please.
Sir, so just a follow-up question, a short one. You already answered the majority of it. The question now is, if you switch with the I-485J to a new employer, and you don't do H-1B transfer, you work on EAD, then if the EB2 date becomes current, and you want to file a new application under EB2, do you have to be on H-1B, or you can do it on EAD?
And this is a lot more complicated. In my opinion, the answer is not clear. Okay, so here is what our situation is. The situation is, let's say I am AC-21 eligible with my EB2 filing, right? My EB2 filing is AC-21 eligible. Then my EB3 also becomes current, right? My EB3 also becomes current, and it also becomes AC-21 eligible. That means both have been pending 180 days. I think I can interfile even while I'm with another employer. Not sure, but I think so. Although I have my doubts. Why? Because this gets a little complicated. Usually what happens is when you go from EB3 to EB2 or EB2 to EB3, if you are working for the same employer, there's no problem. If the same employer did the EB2 and EB3, that's an easy one. But once you have moved out of that employer, your 485 would not be, you could not file a 485 without a job offer, right? You are with another employer. Unless you have a job offer for the EB2, can you still do interfiling? Ooh, I don't really know the answer to that question. Okay. I would suspect that I can. Why? Because once both cases become AC21 eligible, I become free of the employer. But if I'm not AC21 eligible, that is my I-140 either is pending or 485 is pending less than 180 days. If I want to interfile, I probably can't. I cannot. But if both my cases, EB2 and EB3 are AC21 eligible and I have moved to some other employer, I think I can do it. That's my interpretation of the law.
So, sir, you're saying if you stay with the same employer, then it becomes simpler. So my question was mainly about filing a new application under EB2 while the EB3 485 is pending. Now, let's say if you stay with the same employer, what I heard from other forums was that if you have a straight EB2 and if you file 485, it goes to National Benefit Center, and the National Benefit Center is faster in processing compared to Texas or Nebraska. So if you stay with the same employer, but don't do H-1B extension, come on EAD, because the employer doesn't want to spend money on the H-1B now, then can you file a new application on EB2 while the EB3 is pending, if the EB2 becomes current?
I'm confused with your question. I don't know what you're asking me. Forget about National Benefit Center. Forget about all of that. Whoever told you that did not take into consideration that government can send any case anywhere. They reassign work all the time. Cases get assigned to Texas, to California. Cases move around, and you have no control over them. Okay, so I'm not sure where that comes in.
So, in your opinion, interfile. In your opinion, is interfile better or filing a new 485 for EB2 better with the same employer?
I would probably interfile. Okay. I would probably interfile. Of course, we are always keeping track of new developments. If these things change, we will have to decide. But if you ask me as of today, I would not do a second case. I would just interfile on top of the pending I-485. All right?
Okay, sir. Got it. Thank you, sir.
Good luck, sir. Area code 801. Where are you calling from?
Hi, Rajiv. I'm calling from Houston.
Hello?
Yeah. Hi, Rajiv. I'm calling from Houston.
Yes, sir.
And I had a similar question on EB3 and EB2. So last October, I filed my 485 in EB3 as primary, and my wife filed in EB2 as her primary, and then I was the dependent. So now I've got two EAD cards, like one as my primary 485 and one as her dependent 485 EAD card. Now, let's say if I want to, use AC21, both are AC21 eligible because she has crossed her 180 days, I have crossed my 180 days. And everything. Does it matter which EAD card I use?
Let me think about this. So I have my 485. I've got my EAD. I've got an EAD through her. If I use an EAD through her, can I still? Absolutely. Yes, you can.
So the 485 processing would still continue, basically.
In my view, it should make no difference.
My 485.
Yeah. In my view, it should make no difference. Okay.
Okay. All right. Thank
That's
you.
my opinion. All right. Good luck.
Okay. Thank you.
Bye. Okay. Let's go on to the next frequently asked question. So there was some frequently asked questions along the same lines from two different people, or maybe the same person with two different IDs, working outside the USA for 4 months with a recently issued green card. I got my green card last month. I'm planning to go to India and work from India for a US company for 4 months. This is the same company that sponsored me for my green card. Is it legally allowed? Yes. Because you are not abandoning your intention to come back within 4 months, which is less than 6 months. That's always a good idea. When you come back to the United States in less than 6 months while you're on a green card, your degree of scrutiny upon your entry is much, much lesser. Okay? And two, you have not given up your intention to remain in the United States. If, on the other hand, you packed your bags and surrendered your premises and you have no home in the United States, I would have a problem with that. That needs to be addressed. Okay? Even for 4 months, I would be a little hesitant to advise, yeah, it's easy to do that. I'm actually writing an article for the Economic Times about abandonment of green cards. So I'll probably put this in there too, that what are the parameters of leaving after you get your green card? Will there be any issue to port of entry? I don't think so. What type of issues and questions? See, less than 6 months, they don't scrutinize that rigidly. You're allowed to do that. But if you do it several times in a year, you go away for 4 months, I think that's problematic. Unless there are some unique circumstances in your case, you're working on a project. We had a PhD candidate who was doing that. She was working from, I think, Nigeria. Sometimes you have to do that. That was a part of her PhD thesis. So even though she had a green card, she kept going back to Nigeria and she was spending very little time in the United States. But that was very temporary. So it depends upon the case. If you leave for less than 6 months, your scrutiny upon re-entry is not likely to be great. If you don't abandon your permanent home in the United States, no intention to abandon your home, intention to come back in a relatively short period of time, you should be okay. And you should not have given up your job in the United States. In this case, you are working for the same company who got you a green card. I think you'll be fine. Star 5 if you have a follow-up question. Star 5. Okay. Then there's the second part. Somebody else had these questions from Pooja. Got my green card 2 months ago, working for the same employer, pretty much the same pattern. So this one, while working for this employer who sponsored me, can I work for another employer at the same time? From within the US? Yes. While working for this employer who sponsored me, can I work for another part-time employer? Yes. Do you see any issues if I work remotely from Delhi or India, say for 3 months? Now this becomes a little bit more complicated. Okay. My answer to all these questions would be, it will be okay as long as you're not just giving up your green card job, even though that's another set of criteria altogether. Sometimes you can give up your green card job relatively quickly right after getting the green card and still have no issues. You should discuss this matter in detail with your lawyers. But theoretically, all of this is possible. Okay. Star 5 if you have a follow-up question. Star 5. So next question is also close to what we were discussing. Documents needed by and anticipated questions for green card holders at the port of entry. So you are just going to be gone for about 2 months. What documents do I need to carry? Less than 6 months, all I would carry is my green card and my passport. If you have any evidence of continued employment, a couple of W-2s, just scan them, put them on the cloud if necessary. You can show them to the Customs and Border Protection officers. But for exit for less than 6 months and re-entry, they usually don't question too much. And again, if you have any doubts and you would still like to be doubly sure, just like I said, scan your documents, put them on the cloud so they're accessible if necessary. I don't think they'll be asking for those documents. *5 if you have a follow-up question. *5. Okay. Actually, this is not a frequently asked question, but somebody was confused with my answers. When EB2 moves faster, can I interfile to EB2 from EB3 with my new employer B? So I'm confused with your two different answers. Let me see if I can reconcile them. I filed I-485 with employer A, EB2 to EB3 downgrade. I-140 is approved and crossed 180 days of 485 pending. Also EB2 I-140 approved for more than 180 days. EAD is also approved. Join employer B on AC21 with supplement J. When EB2 moves faster, can I interfile? So in your case, what has happened is both your EB2 and EB3 have crossed the AC21 limits. So you are good. In my view, you should be able to interfile. For people who are not AC21 eligible, I think it's a bigger problem. So if let's say that your EB3 I-140 was still pending and you wanted to interfile, I think it'll be a lot more difficult because if you have changed employers, that job is no longer available to you and you're not AC21 eligible. That's the way I read the law. So the difference is being AC21 eligible or not. What is AC21 eligible? I-140 approved, I-485 pending, 180 days. If both EB2 and EB3 are AC21 eligible, you are good to interfile with any employer. That's the way I see it. *5 if you have a follow-up question on this question. It's not a frequently asked question, but I thought it was confusing for people. And that's the way I read the law, guys. If you hear of something different, do educate me, because these are not issues of law. These are really issues of policy at this time. Now let's go back to the other questions, which are non-frequently asked questions. This is question number 4. So a Canadian citizen overstayed their visitor visa, then they've been outside for more than 10 years. Can they come back? Yes, absolutely. But can this be an issue at the border? Yes. They can say, hey, wait a minute. Last time you were in USA, you stayed for over a year or without status. How are we to know that you won't do the same thing again? They can raise it as an issue, but legally you are not barred from coming back. I hope that helps. So it's a practical problem, not a theoretical one. Just be truthful, whatever the truth is. Hope for the best, but as a practical matter, it can be an issue of concern to the Customs and Border Protection. *5 if you have a follow-up question. *5. Okay. Options for applying for a new H-4 EAD. On H-1B, there's 2+ years left. Spouse is on H-4. And 797 is good for, is that less than or greater than? Less than 1 year. Never filed H-4 EAD for my spouse, planning it now. Apply for H-4 EAD using the existing H-4 or extend H-4 and then apply. I think extend and apply EAD at the same time. Is it possible to extend H-4 before 6 months of expiration? I'm not sure. I would like to call the USCIS and ask them and explain why I'm extending, because I want to get EAD for as long as possible. I think they should allow it. That's what I would do. Because it's taking so long for EADs. It's rolling the dice. If you apply for an EAD now, you get it 8 months later. By that time, the current H-4 has expired. You're filing for an H-4. I think it's too messy. I think extension and EAD should be applied at the same time. *5 if you have a follow-up question. *5. Okay. Call the USCIS. Have your lawyers call them. It takes all day to get through, but we can usually get answers from the USCIS. Okay. No questions? Let's go on to the next one. Now this is another interesting question. What happens when an F1 applies for DV lottery? Now I'm not a DV lottery expert, but my understanding is that consulates don't consider just applying for the lottery to be immigrant intent. I don't know why or how, but it looks like they can ignore it if they so choose. Okay? But you can double check with somebody who does DV issues more regularly than we do. I have done one DV or two DVs, I think, in 20 plus years of my practice. 30 years of my practice, I don't know when DVs came into place. I remember when they did. We did a couple of them and then realized you don't really need a lawyer for these. So we stopped doing them. Okay. Let's see. I'm an Egyptian citizen, currently on F1, got selected in the DV lottery. I was born in Kuwait. US Embassy in Egypt hasn't been working full capacity. Thinking of going AOS. You should do AOS, absolutely. Wife is also, she's a PhD living in Japan. Come here and before I file, go through AOS together. Yeah, this is much more complicated, you guys. Because if she enters on a student visa and applies for an adjustment of status, that's preconceived intent. That's a big problem. I think you should do her, I think she should do her CP. Again, check with DV people. Does she have to be approved in the same fiscal year? Because DV lottery people, as far as I remember, they have to be approved in the same fiscal year. Or is it they just have to file in the same fiscal year? I don't remember exactly how it works. But is she confined to the same fiscal year cycle as you are? But I would be very concerned about applying for a 485 right after I enter. Okay. But do check with somebody who does DV lottery cases. I am not the guy you want to talk to. Okay. Misdemeanor case with I-485. So I've got a misdemeanor case. Police arrested me. Judge gave me 40 hours community. So what documents do I need to submit? So you know what? If you are concerned about talking to your company lawyer about this, you should just change your lawyers. Go to another lawyer, get your own lawyer, and tell your lawyer that, look, I have to get myself another counsel. That way, the second lawyer works only for you. And that takes care of the problem. I think your company lawyer would have a problem. So if I represent the employer and the employee divulged something to me, I would have a problem keeping it confidential. All our paperwork to our clients tells everybody, look, we represent both the employer and the employee. You are both our clients. We owe you both equal loyalty. I'm not going to do anything that hurts one against the other. So there could be a conflict situation. Easiest solution to this is get yourself a outside counsel. Change your case over to them. And you should be fine. It doesn't look like a big problem. Star 5 if you have a follow-up question. Star 5. All right. Then comes pile 786, EB2 to EB3 downgrading. 20 years of IT experience, MCA from India. New company agreed to file a green card in EB2 category. Attorney told me she's preparing in EB2 category. Okay, well, I don't know what this lawyer is thinking, but here's the bottom line. You can file a PERM in EB2 and choose EB3 at the I-140 stage. But if you file a PERM in EB3, you cannot change to EB2 at the I-140 stage. You can downgrade, but you can't upgrade. So smart people always file PERM in EB2 category, but at the EB3, at the I-140 category, they sit with the client and decide whether to file I-140 under EB2 or EB3. I don't know what this all means, ma'am. You've got to talk to, if you want a second opinion from me, I need to look at everything. I can't really tell you what your lawyer is thinking. What all things need to be done to file green card application EB2 category? Till now, they got prevailing wages for below job description. I don't have a job description. My last 2 green cards were filed in EB2 category. Got I-140 without any problem. I don't know what the lawyer's problem is. You can ask her for an explanation. So I'm not going to be able to help you beyond what I just told you. That wherever possible, and I think you are on board with me, wherever possible, file under EB2. Okay. Ask your lawyer to explain to you exactly what the problem is. None of this makes sense to me. *5 if you have a follow-up question. *5. Okay. I think we have covered these questions. Now we come to, does a dual citizen of the US need to be present for a certain time in the US for processing green card for adult children when dates become current? Okay, so the way this works is, I had this consultation today only, that when the US citizen applies for their relatives, when the relatives go for consular interview for green card, which is 2 years down the line after you file, you have to be either domiciled in the United States or be in the process of being domiciled in the United States. This is a requirement of the affidavit of support. You've got to be either moved back to the US or be in the process of moving back. Before that, you don't need to be in USA as far as I know. Okay, so it is important for you to be domiciled or in the process of being domiciled when they go for their green card interview. *5 if you have a follow-up question. *5. The next question, number 15, is issue with inconsistent reference to educational institute. University referenced in academic equivalency and just the college within the university referenced in PERM. I think you should be okay because they are both correct, right? So, for example, my university was Punjab University, but my college was the law faculty. So they are both correct designations as far as I'm concerned. Yeah, I think you're going to be fine. I don't think it's a problem. All right. *5 if you have a follow-up questions. *5. Okay. Anyone has any question, press *5. Anyone has any question, new, old, press *5. Okay. Let's get started. Area code 903. Where are you calling from?
Sir, California.
Go ahead, sir.
Yes, sir. So this is a follow-up question to a previously asked question about applying under EB1. So my current employer, who is my GCM sponsor employer, I have EB2 and EB3 both approved with the employer. Downgrade application was filed under EB3, and the 485 has been pending. I received the EAD and AP. So the question is, recently my employer was reviewing options for my expediting my green card, and also looking at other areas where he wanted to utilize my services. So one of the options he gave me or offered me was to go to India and develop his business unit over there, and then he could think about applying under EB1C. So basically, I would be going there, opening the company office over there, hiring folks over there, getting the business started over there, doing business development and stuff. So my role will be executive role over there, and then I will be coming back after a year or 2 years.
Okay. Let me interrupt you. Let me interrupt you for a second. This is a very common situation. We have done many cases like this. Okay? It works fine.
Okay.
As long as you meet the other requirements, talk with your lawyers, plan in detail, definitely workable, no problem at all. Okay?
Okay, sir. So there is no issue in terms of USCIS thinking that
Didn't say that.
guy has EB2, EB3, and now
Never said that.
Okay.
That's why your lawyers are there. They have to examine everything. I don't think it's a problem. Every case we did was cases where people had EB2 pending, EB3 done, something like that. It all works out. All right.
Okay. Thank you, sir.
You're welcome. Good luck. Area code 815, where are you calling from?
Yeah, hi Rajiv. This is Bhupal calling from California.
Yes, sir.
Yeah, thanks for taking my call. Rajiv, my question is related to the downgrade petition. My employer filed EB2 to EB3 downgrade petition in last year October. But initially what happened, right? Initially the petition got rejected saying the reason like incorrect fees, but everything was already included in the package. So basically it is a mistake on USA's part. They overlooked the package and they didn't check all the checks and they sent the package back. But we received the package in January first week, on January 4th. So my attorney just checked everything and he said everything is already there, but they rejected it incorrectly. And he put a letter saying that everything was already there. Just please accept my petition. Please accept the petition with the world review date. But they accepted the petition this time, but they did not issue the world originally delivered date, that is October 26th. So instead of that, they put January 5th as a receipt date. That is when they actually received the second time petition. So January 5th means in the January, but actually my priority date is 2013 November. Even though the priority date is current in dates for filing chart in January, but they are not honoring the dates for filing chart in January. So my question is, even though they accepted the package, but they gave the receipt date as January, right? So my question is, will I have any problem during the adjudication?
I do not know the answer to I do not know the answer to that question. So when the government accepts a case, even though it is outside time, and they receipt it according to the date they have received, and that date is not within the current dates, will you have a problem in the future? I can't predict that. I have no way of knowing. The only thing I would recommend is contact your congressman's office. This is a tough issue. They should talk with somebody inside the USCIS. Your employer can contact a congressman's office. They can get you that information. Okay?
Okay. Well, in my case, the date is current, but they were not honoring the dates for filing chart. So even in that case, you think it will be an issue because
it's the same. It's the same problem. It's the same problem. You just stated it differently. It's the same problem. Have your employer contact their congressman's office. Okay.
Okay. Did you see this kind of issue in your experience?
I have seen every issue in the world. That's why I told you to contact your congressman's office.
So you think it will work if it
Sir, I've got 5 more people waiting. I've told you what to do. Do it.
Okay.
Good luck.
Thank you. Yeah.
You're welcome.
Thank you.
You're welcome. Area code 609, New Jersey. Go ahead, please.
Hi, I'm Karthik here. Thank you for answering my questions regarding the interfiling, which I understood that once the AC-20 law is passed, whether I'm in current company or new company, or whether I'm H-1B or EAD, it doesn't matter. I can interfile it.
Right. That's the way I see it. Okay, hang on. That's the way I see it. Because in my mind, once you reach the AC-21 threshold, you become free of the employer. But until you reach that threshold, you are still stuck with the job offer. Okay? And the job offer comes from that employer who did the I-140. That's a different situation. Okay. That's the way I see it. Maybe I'm wrong. Maybe I'm right. But to the best of my analysis, that's how it is. Go ahead, sir. What question did you have?
Okay, the only question I have is, since I am actually my current priority date is actually 2014, which got regressed to 2012 in EB3, but in EB2 is 2013. So the question here is, can I interfile now, or I should only wait when the filing date becomes current?
They're not honoring interfiling until the dates become current, to the best of my knowledge. Now remember, this is not a matter of law, it's a matter of policy. If the government changes their policy, great. But right now, if they are following the old policy, they won't interfile until dates become current. They won't even entertain the request.
Okay, so when you say current, it can be filing date or final action date?
I think it
Am I right?
can be
Or
even
only final action date?
dates for filing. I think that should be enough.
Okay, that's very good. Thank you very much. I appreciate your answers.
You're very welcome. Good luck. Area code 480. Where are you calling from?
Hi, I'm calling from California.
Mm-hmm.
So my STEM extension got denied, and I guess I was just wondering if filing a motion to reopen or reconsider would be worth it, or if that's a good idea.
Miss,
Because
what was
the
the...
grounds on which
Yeah, tell me what were the grounds.
I applied 3 days before my DSO did, so the grounds are technically correct. So I'm worried if there's there's any point in applying or.
As far as I know, they will not anything that is, because the deadlines are regulatory. They are by regulation. I don't think the government can help you much if you apply too early or too late. That's to the best of my knowledge, ma'am.
Oh no, I wasn't. It wasn't late or anything. It was within the right period of time.
Mm-hmm.
It was just before the DSO's recommendation.
But the DSO's recommendation.
And I guess it was
hang on. Was the DSO's recommendation backdated to the date you applied, or did they front date it? In other words, when you applied, there was no recommendation.
Technically, yes.
Okay. So if I were you, I would ask my DSO to please check with a couple of other DSOs, see if there's any way to work this out. Okay. To the best of my knowledge, they will not reopen the case. To the best of my knowledge. But if you wanted to take a chance, miss, what do you have to lose? It's a few $100s more, right? Give it a shot.
Yeah, I guess that's true.
Okay. I don't think they're going to do it. Don't hold your breath. But doesn't hurt to try. I would have my DSO call some other DSOs, people who have experienced this problem.
Okay.
All right.
And in terms of status, if my previous OPT ended on August 30th,
Mm-hmm.
does that mean that my status technically ends tomorrow? Because
Yes.
that would be 60 days?
Yes. You have 60 days. Okay. Now, remember, after 60 days, you no longer have status, but you might still have an excuse that the reason you are staying back is because you're trying to resolve this mess. But I would be careful. See if your
Right.
service can be rolled over. Okay. Talk to your DSO.
Yeah, I'm trying to
Right.
move my status over.
Yeah.
So that wouldn't be unlawful, right?
I think it should be okay if it's done within 60 days. But if it is done past 60 days, you probably
Okay.
will have to go out and come back in. Or get reinstated. I don't think you can get reinstatement. I think you'll have to go out and come back in again. Okay?
All right.
Good luck.
Really super quick. Another attorney mentioned an NPT request, but I don't know if that's really applicable
See,
to my
no.
case.
There is no mystery to NPT. What is NPT? Nunc pro tunc simply means this. Even though you are approving my case today, approve it going back to the date XYZ date and time. Okay. In your case, there is no XYZ date. Why? Because on the day you applied, you didn't have a regulatory precondition, which is the approval of the DSO. Therefore, what can they backdate to? They can't backdate it to the approval because the approval came after your filing. So the filing was wrong. They can't correct the filing through NPT. Okay. I don't think NPT would work. But look, listen, I'm very humble because I know immigration law is far more complex. There are too many variations, too many ways things can work out. I wouldn't be so brash as to say absolutely not, you can try, but I don't think there is any NPT room here.
Okay.
All right?
Thank you.
You're welcome. Good luck. Okay, the last call for the day is from an anonymous, probably a voice over IP. Go ahead. What is your question, sir or ma'am?
My question is, I got my I-140 denied in 2018. It was from a startup company. Now with my current employer, I got my H1 cap approved, and I have got a visa interview in the next month. Will there be any problem because of previous I-140 denial?
The only time I would worry is if there is some misrepresentation or fraud on your part. Just because the I-140 got denied, absolutely no problem. Don't worry about it. Okay?
Because that was from startup company.
That's okay. I'm hoping that in the DS-160 you did mention that somebody had applied for your green card.
No, because this DS-160 is filled from my employer.
What?
Do we need to mention that?
Yes, of course.
Do we need to mention about?
Of course. And DS-160 you file, not your employer.
In our company, company will take care of
That sounds illegal to me, because that's your personal statement under penalty of perjury. How can they do it? Okay. So I'm not sure what happened here. Yeah. But there's a question in the DS-160, I think, which says, have you ever applied for a green card? The answer is no. Has anybody ever applied for a green card for you? The answer is yes, because that I-140 is an application for an immigrant visa. It's a minor thing. It's not a major issue, but it should have been mentioned. It should be taken care of. Okay?
Okay, yeah, sure.
Good luck.
Okay, thank you.
You're welcome. All right, folks, that's all the questions we had today. Good talking with all of you, and I'll see you again in 2 weeks. Everyone, take care.